2-count indictment of illegal conveyance and aggravated possession of methamphetamine that occurred on Tuesday. And the court set bond of $5,000 in the absence of counsel and due to the requirements of Rule 46. The court is conducting a bond review at this time with counsel Mr. Ryder.
Yeah, he was just arraigned, so I do have the file. I don't have all the discovery yet. The bond is relatively low at this time. We just sort of right to file a modification once I get to know my client a little bit more, Your Honor.
All right. Yeah, anything you want to add, Mr. Knight?
No, Your Honor.
Okay. Because he does have previous felony convictions for breaking and entering and unlawful sexual contact with a minor. So, write down the, so for now, in the motion, or the bond will make sense. All right, thank you.
Yeah, I'll talk to you.
I'm sending this to you.
All right, are you Jordan Kelly McCracken?
Yes, sir.
Okay, we have 2 cases here involving the same defendant, Jordan Kelly McCracken. State case number 21 CR 48 CR 101. Mr. McCracken is appearing along with his attorney Nathan Wagner by video from the jail on Zoom. Assistant Prosecutor King is appearing on behalf of the state. Mr. Wagner, you and your client are stipulating to the appearance before the court by video rather than in person.
We are.
You're in agreement with that, Mr. McCracken?
Yes, sir.
All right, thank you. All right, case number 21 CR 48. Defendant is charged with felonious assault on a peace officer, assault on a peace officer, and vandalism. And I know that case is set for trial. Not quite sure when, but I think sometime this month. And then in case number 21 CR 101, he's charged with 2 counts of aggravated trafficking of methamphetamine and 2 counts of aggravated possession of methamphetamine. That trial is set for August 9th. And the first case was actually set for June 24th, and then it was continued. So, in any event, matter was set for a hearing this morning, requested parties. And Mr. McCracken, I have been presented with a plea agreement in each of these 2 cases. Now, these agreements are prepared by the prosecutor from a form that they have in their computer. And the first one I'll hold up to the camera is the 21 CR 48 case, which is the felonious assault on a peace officer. And it says you're going to withdraw your plea guilty to that charge. That's page 1. Do you see that agreement there? You see that on the screen?
Yes, sir.
All right. And then on page 3, there are signature lines. About halfway down, there's a sentence that reads, "I enter this plea voluntarily," and then there's a signature, and I'll put that up to the camera. Do you see that sentence right below my finger and then the signature?
Yes, sir.
And is that your signature?
Yes, sir.
All right. And then in the 21 CR 101 case, I'll hold this up. That is the trafficking and methamphetamine charges. You see that plea of guilty with your name, and it says you're going to plead guilty to counts 1 and 3.
Yes, sir.
And on page 3 of this form, again this goes down toward the bottom. There's also a statement that says, "I enter this plea voluntarily," and a signature, and you recognize that signature there being yours.
Yes, sir.
When did you sign these agreements, Mr. McCracken?
Yes, today, sir.
All right, and was Mr. Wagner there with you when you signed them?
Yes, he would.
And did he go over these with you and explain them to you?
Yes, sir.
And did you understand that when you signed these agreements that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did you feel that you had enough time to fully consider this matter before you made the decision to plead guilty?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily in each case?
Yes, sir.
All right, now in case number 21 CR 48, the agreement states on page 1 that you're going to withdraw your not guilty plea and plead guilty to count 1, felonious assault on a peace officer under 2903.11A2, a first degree felony. Further states that you understand maximum stated prison term for that to be imposed by the judge is 11 years. It runs from 3 as a minimum up to 11 as a maximum, and there's a fine of $20,000 possible, and there's a presumption there should be a prison term imposed. Now, in this particular case, the sentence that you are convicted that is imposed by the judge is a minimum sentence that you would have to serve. And then the Department of Corrections, under the sentencing law, does have the authority, if they decide it is appropriate, based on their evaluation of your situation while in prison and the defense and other factors that they consider, and I can't tell you what those are because I'm not involved in that, but in any event, they would have the authority to make you serve up to 1/2 of the term that is imposed by the judge in addition to that term. So let's use the minimum as an example. If you receive 3 years on this charge in the court, you would serve that, and then the Department of Corrections could decide you should serve another 1.5 years, because 1.5 is half of 3. So that means the maximum term under that situation would be 4.5 years. Now, if you receive the maximum prison term available that the judge can impose, which is 11 years, then after you serve that, the Department of Corrections could decide you should serve an additional 1/2, which would be 5.5 years. So that means that in that scenario, it could be a maximum sentence of 16.5 years. You understand that?
Yes, sir.
Okay. Now, in case number 21 CR 101, it states that you are going to withdraw your not guilty plea, plead guilty to counts 1 and 3, both aggravated trafficking and methamphetamine. Count 1 is a 3rd degree felony, and count 2 or 3 is a 2nd degree felony. And so on the count 1 charge, the maximum prison term that's available is 36 months, could be a minimum of 9, or any range in between that is provided by law. It goes from 9 to 12, and then 6 months, increments up to 36 months after that. And a fine of $10,000, and a mandatory fine of $5,000, a possible license suspension of 6 months to 5 years, and a possible prison term, or a presumption that prison term should be imposed. You understand that?
Yes, sir.
Now, on count 3, that is a 2nd degree felony. And the maximum prison term that could be imposed by the judge in that case would be 8 years. The minimum would be 2 years. And again, that is the same as in the other charge. Because it's a 2nd degree felony, that would be the minimum charge that the judge could impose. Then, once you serve that, the adult parole authority could decide to increase your sentence up to 1/2, which would be, if it were 8 years, 4 more years, or 12 years is the maximum. You understand that?
Yes.
Now, under the law, the court can impose consecutive prison terms. And let me back up. The 8 years on count 3 is mandatory. We no early release on that. The other one is not mandatory. The count in the felonious assault charge is not mandatory, nor is count 1 the aggravated trafficking. But count 3 in 21 CR 101 the aggravated trafficking of methamphetamine, the second-degree felony, is mandatory. So whatever sentence you get, you will serve all of that before you can be considered for early release under judicial release. You understand that?
Yeah, and that's what we were explaining, Your Honor. I indicated to him that one count, no matter what, if he ever filed, he had to serve that.
Right. Okay. So, if I ordered all of it, let's assume worst case scenario purposes. You plead guilty to all three of these charges, and I sent you the maximum on each charge. That would be 11 years in 21 CR 48. And count one in 21 CR 101 could be 36 months, which is 3 years, so that would be 14. And then the 8 years on the third count in the 21 CR 101 would be added to that, so that would be 22 years. That would be the sentence that could be imposed as a maximum by the judge. Then the 8 years would be served first, then the other 2 charges after that. And then on the count 1 in 21 CR 48, you could then get an additional 5.5 years on that. Because, and again, I think I'm right on this, counsel, when we have 2 rated coach cases, sentences, the 50% of the longest term imposed, regardless of the degree. That agree with that, Mr. King?
My understanding that it would apply to the most serious qualifying offense,
Okay, yeah. Well,
which would be the F1.
yes, so the longest minimum term for the most serious felony. So that would be count 1. So you wouldn't get 50% on both count 1 and count 3 in the 101 case. You would get 50% of the 11. So adding that all up, that would be 11 years plus 3 years is 14 plus 8 is 22. It would be 4 years served mandatory on the second degree felony. But because the felonious assault is more serious than that charge, it's a first degree instead of a second degree, then the additional 50% under the rated coach law could be imposed by the Department of Corrections on that, which would be an additional 5.5 years. So that would mean the total possible sentence, if the things went absolutely the worst way for you possible, would be 27.5 years. Understand that? Pardon me?
Yes, sir.
Okay, and did I get my math right, counsel? I think.
Yes, Your Honor.
Okay, all right, I don't claim to be a math expert, that's why we've got calculators. All right, now, other than these 3 charges, are you facing any felony charges anywhere else, Mr. Brack?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No, sir.
Okay. Now, under the law, on the felonious assault case, in 21 CR 48, and on the first count of 21 CR 101, the aggravated trafficking methamphetamine for third degree felony, you could get community control. You can't on count 3. But just to explain to you, what that means is instead of going to prison, you would be put on supervision on the terms set by this court under the supervision of probation department for a period of 5 years. And if during that period of time you were found to have violated those conditions, at that time the probation department will file a written notice of that. There would be a hearing, and you'd be represented by counsel. And if the outcome of that hearing was that you had failed to comply, then at that time the court would revoke your community control and send you to prison on those 2 charges to 36 months on the aggravated trafficking charge and 11 years on the first degree felony charge. You understand that?
Yes, sir.
And again, that's not going to happen in this case because I don't get a split sentence like that. Some judges do, where they will sentence you on a mandatory, and then wait till you get out of prison and put you on community control. But I don't do that. It does, because if I decide you should, if you do well in prison and so forth, you could be eligible to get judicial release after you serve your full 4 years, plus then you have to serve, depending on length of the sentence, anywhere from 30 days to 5 years before you file again, but you could file. So that's the reason I do it that way is, we consider it that time instead of having somebody serve years and years and not go on community control. Okay. Now, do you have any questions about that?
No, sir.
All right. Now, in the 21 CR 48 case, the First County indictment alleges in on or about April 2, 2021, in Highland County, Ohio, you did cause or attempt to cause physical harm to Officer Dylan Tharp by means of a deadly weapon or dangerous ordinance, to wit, an X2017. Said Officer Dylan Tharp being a police officer defined in ORC section 2935.01, which would be a violation of section 2903.11A2, the charge of felonious assault against a peace officer. Again, a first degree felony with a possible term of a minimum by the judge of between 3 and 11 years, plus an additional 1/2 of that to be imposed by the Department of Corrections, and a fine of $20,000. And Mr. King, I don't know what an X2017 is. Is that a taser?
Taser, Your Honor.
Okay, I kind of thought it might be, but I wasn't sure. All right. Now, count 1 in 21 CR 101 alleges that on or about December 9, 2020, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in an amount equal to exceeding bulk amount, but less than 5 times bulk amount, in violation of section 2905.03A1. Count 3 alleges you did the same thing on December 11, 2020 through December 12, 2020 in this county. And at that time that you offered to sell or sold methamphetamine, Schedule II controlled substance, an amount equal time, exceeding 5 times bulk, but less than 50 times bulk. And so, same statute. Both of those are the same offense, but count 3, because the amount involved was more than 5 times bulk, it raises it 1 more degrees from a felony 3 to a felony 2 with a mandatory prison term. So, you understand what you've been charged with in those counts of the indictment I just read to you, the 2 indictments, what the state says you did, when, where, how, alleged you did it in each case?
Yes, sir.
Have you discussed the nature of each of these charges, the evidence applicable to each charge, the possible defenses you might try to raise in each trial and each charge, possible legal issues as to each charge, and a possible outcome of the trial as to each charge with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Right now, in the first case, 21 CR 48, there's a printing in bold down almost at the bottom of page 2. I'll hold that up there. You see that?
Yeah.
All right. It reads as follows. Defendant shall enter plead guilty to count 1. State will dismiss remaining counts. State defense jointly recommend 4 years incarceration consecutive to the sentence imposed in case number CR 21 CR 101. And that would be the agreement in that case. Now, shift the paper around now, I'll lose it. There it is. The second case, 21 CR 101, on page 3, there are several sentences printed in bold and underlined. I'll hold up there to the camera. And you see those?
Yes, sir.
All right. I will read that to you. Defendant shall enter plead guilty to count 1 and count 3. State will dismiss the remaining counts. State defendants jointly recommend 12 months incarceration on count 1, consecutive to 3 years, mandatory incarceration on count 3, consecutive to sentence imposed in 21 CR 048. Defendant shall pay restitution, $1,100 in restitution to the Hyman County Task Force as a condition of the plea agreement. Is that your understanding of the agreement in that case?
Yes, sir.
Now, has anyone promised you anything other than the agreement that I just read into the record on each of these cases?
No, sir.
Now, under the law, Mr. Kraken, the matter of sentence is up to the judge, not the parties. So even though you and the state are agreeing as to what the sentence ought to be as to these two charges, which looks like it's a total of 3 years mandatory plus 12 months in the 101 case, so that'd be 4, plus 4 additional years in the police assault case, which would be 8 years. That's the recommendation, but again, as I explained to you earlier, there's actually the potential that I could impose up to 22 years in the minimum, which would increase the maximum to up to 27 and a half years possible, depending upon what the Department of Corrections did on your police assault charge in the 48 case. You understand that?
Yes, sir.
Mr. Kane, did you consult with the victim in the 48 case and as far as his input on that is concerned?
Yes, Your Honor, the officer has been consulted with, and he is in approval with this agreement.
Okay, thank you. All right. Now, you have certain constitutional rights you must understand, Mr. McCracken, before I can accept a guilty plea from you in either case. First of all, you have a right to have counsel. Mr. Wagner was appointed to represent you, not simply to try to work the cases out, but to defend you in any way possible under the law, as you wish. So, if you decide you don't want to plead guilty in either of these cases, or both, he will still represent you and defend you. And that would include having a trial in each case, if that's what you want. You understand that?
Yes, sir.
Right now, under the law, in the Constitution, Mr. Kraken, you have a right to have a jury trial in each of these two cases. And in this case, it'd be 2 separate trials. So you would have a jury in each case selected, and it would be 12 people that would be chosen from a group of citizens from this county in each of the cases that would be summoned for jury duty on that trial. Now, after the 12 jurors are selected in each of the two cases, the evidence would be presented, they'd be instructed on the law. And then the jury in each case would have to decide by a unanimous verdict, meaning all 12 would have to agree to a verdict in each of those cases, as to whether or not the state proved your guilt on any of the charges. That's in either case. Now, if you didn't want to have a jury trial in either case, or both, as you chose, you can waive that right, which means to give up. It would have to be in writing. And so you would waive the right to have a jury trial, and then you can have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt in each case by proof beyond a reasonable doubt, as you chose. You understand that?
Yes, sir.
All right, now, under the Constitution, you have a right in each of these cases to confront the witnesses against you and to cross-examine them through your attorney. And what that means is that the witnesses in each case would have to come into court and testify in open court in front of anybody that's here or watching. And then after the state was done asking questions in each case of those witnesses, your attorney could ask questions, and that's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Right now, in the Constitution, you have a right to confront the witnesses against you and cross-examine them through your attorney in each case. So what that means is that they would have to be here in open court, and then your attorney would be asking questions to try to bring out evidence that will help your side of the case. And I think I just said that, but again, you do understand that.
Yes.
Okay. Now, you have the right to use the power of the court in each case to subpoena witnesses to come to court to testify for you, just like the state. So if you have witnesses in either case, or both, that that you're not certain going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena. That forces those people that are subpoenaed by you to come to court to testify, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you in each case. Do you understand that?
Yes, sir.
And now, in each of these cases, Mr. McCracken, you have a privilege against self-incrimination under the Constitution. That means you cannot be forced to testify or to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way, at any time, by any person. And in fact, no one's even allowed to talk about it, except in one situation, and that is if you have a jury trial in either or both cases, then, and elect not to testify in those cases, or either case, then the judge will instruct the jury, and in that case, or cases, that that is your right under the Constitution, and that they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right, now, Mr. McCracken, under the Constitution, you are presumed innocent in each of these cases of the charges until proven guilty by the state of Ohio by proof beyond a reasonable doubt as to every material element of the offense charged in each case or offenses. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence in your own defense at trial in either of these cases. You may, but you're not required to. But whether you present any evidence in your defense in either case or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt in every material element of the offense charged in each of the cases by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right, now, you entered a plea of not guilty originally, Mr. McCracken, in each case. Plea of not guilty denied the allegations in the indictment. In each case, denied that they were a crime or that you committed any crime. And that plea exercised or revoked all the rights I've just described for you in each of these two cases. Now, if you change your plea, excuse me, from not guilty to guilty, that is the complete opposite of not guilty plea. That means that in each case, you admit the allegations and the counts of the indictment that you're pleading guilty to, admit that those are a crime, that you committed those crimes. And that plea, in each case, would waive or give up all the rights that I've described for you this morning, except your right to have an attorney. Because you always have a right to have an attorney no matter what your plea is. But with that exception, your plea of guilty would waive or give up your right to have a jury or court trial, would waive or give up the right to confront witnesses against you if you cross-examine through your attorney. It would waive or give up the right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your presumption of innocence in each case, because if you say you're guilty, that's what you find you guilty. Each case, it would waive or give up your presumption of innocence, because if you say you're guilty in that particular case, then the state is not required to prove that you're guilty. It also subjects you to being sentenced immediately by the court, which is what's likely to happen since there's a mandatory prison term involved. And it waives and gives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I should sentence you to the maximum sentence on any of these charges, or under certain circumstances, you could file an appeal. It would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. attorney? Are you a U.S. citizen?
Yes, sir.
Okay. One other question I didn't ask you, I don't believe. Do you hold any license or certification from any state agency or board for any kind of an occupation or profession? You know, like a nursing assistant or dental assistant or something like that.
No, sir.
Okay. All right, now, do you have any questions about the charges in either of these two cases, Mr. McCracken?
No, sir.
You understand them?
Yes.
You understand the penalties for each,
Yes, sir.
including the possibility that you could serve longer than what I specify on the what is assault charge, since, the parole authority could add up to half of whatever term I'm opposed to you on that case, you understand that?
Yes,
Do you have any questions about the plea agreement?
no, sir.
You understand it?
Yes,
Do you have any questions about the constitutional rights I've explained?
no, sir.
You understand those?
Yes,
Do you have any questions about the plea of guilty, what it means, or what will happen today if you enter that plea?
no, sir.
You understand?
Yes.
Now, is there anything you'd like to speak with Mr. Wagner about before we go any further in this case?
No,
Do you have any questions at all about anything that I've explained to you here this morning?
no, you don't.
All right? Then, Mr. McCracken, is it your decision to withdraw your plea of not guilty, plead guilty to count 1 and 21 CR 48, and counts 1 and 3, case number 21 CR 101, pursuant to the terms of the written plea agreement in each case that we've gone over here this morning?
Yes, sir.
All right, then, case number 21 CR 48, which alleges in count 1 that on or about April 2, 2021 in Highland County, Ohio, you did cause or attempt to cause physical harm to Officer Dylan Tharp, a means of a deadly weapon or dangerous ordinance to wit an X2017, and said Officer Dylan Tharp being a police officer as defined in ORC section 2935.01, in violation of section 2903.11A2, the Ohio Revised Code, charged with malicious assault on a peace officer, a first degree felony that carries a minimum term of between 3 and 11 years imposed by the judge, with the possibility of additional 1/2 of any sentence imposed by the judge to be added by the parole authority at their discretion, a fine of $20,000. How do you plead?
Yes, Your Honor.
All right, in case number 21 CR 101, count 1 that alleges that on or about December 9, 2020 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance in an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, violation of section 2925.03A1, charged with aggravated trafficking methamphetamine under 2503A1, third degree felony, potential prison term between 9 and 36 months in the increment provided by law, a fine of $10,000 and a possible license suspension of 6 months to 5 years. How do you plead?
Yes, Your Honor.
As to count 3, which alleges that on or about the period beginning December 11, 2020, continuing through December 12, 2020 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance, an amount equal to or exceeding 5 times bulk amount, but less than 50 times bulk amount, in violation of section 2925.03A1, charged with aggravated trafficking methamphetamine, a second degree felony, which carries a prison term, a mandatory prison term of between 3 and 8 years, all of which would have to be served without the possibility of early release, a fine of $15,000, and a possible license suspension of 6 months to 5 years. How do you plead?
No.
Alright. I would also indicate that does have the potential to have an additional half added to it, that if your sentence on the first one, count felony 1, it would be opposed, but if you weren't sentenced on it, it wouldn't. So, but you understood that, right?
Yes.
Okay. Alright. The court finds then that on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to criminal rule 11 in each case. In case number 21 CR 48, the court finds the defendant guilty of count 1, malicious assault as charged therein. Counts 2 and 3 are dismissed. In case number 21 CR 101, the defendant is found guilty of counts 1 and 3 as charged therein. Pleas are accepted in each case in order to file. And in 21 CR 101, counts 2 and 4 are dismissed. All right, now, inasmuch as count 3, 21 CR 101, contains a mandatory sentence, and due to the nature of the offense in count 1 in 21 CR 48, felonious assault of a peace officer, court imposes a sentence anyway, so the court does not feel there's necessity for a pre-sentence report at this point. There's also a stipulated recommendation as to what the sentence ought to be. And so I will go ahead and proceed with sentencing forthwith. First, on behalf of the state, Mr. King.
Only what is contained in the plea agreement, Your Honor.
Mr. Wagner, on behalf of the defendant.
Your Honor, while we understand and appreciate the severity of the situation and the charges, to my client's credit, again, I'm using that as a loose term here, from the moment of the inception of this case, Your Honor, Jordan was ready to enter a plea, the first case. We simply went through the discovery and then we were informed the second case was coming. That is really the only reason for the delay here, Your Honor. We even brought this case kind of quick. He takes full responsibility. This was simply negotiating a settlement with both sides to agree upon the term of incarceration. Again, Jordan has from day one, in meeting with them, admitted to these charges. I think if you look at the case on the first one, there's a video of this incident. It's clear, and obviously the trafficking, the possessions, that drugs are a factor in this. That is a sad factor here. You can tell he was under a substance of abuse. That may be more of an incriminating factor. But sadly enough, drugs have brought this man where he is today. But again, I know 8 years is a long time. George's aware of that. He has children. He's obviously upset. He's going to miss a large portion of their lives. But again, it's just sad another story to see the drug ruining someone's life now. So we ask the court to follow the recommendation.
All right, Mr. McCracken, anything you would like to say?
No, something my attorney said.
The discovery showing him on free control on 19 CR 124. Oh no, I'm sorry. That's
not
clear. I'll say never mind. Okay. I just saw that. Okay, so all right, Mr. McCracken, anything you'd like to say then?
Yes, sir. I'd just like to apologize to all parties and ask for the mercy of the court.
Okay, I'm looking here at discovery for you that you have a prior assault conviction back in 2003 in Hamilton County and then a reckless operation that was a 4-3 misdemeanor, so that's your only prior record. Okay. Well, Kraken, it's unfortunate that you're in the situation you're in because of your decisions, but nonetheless, you're here and you committed some very serious offenses, including one that required to be sent to prison, the one drug charge, plus, you know, my opinion, anyone who assaults a police officer should go to prison, and felonious assault is usually a prison term because it's a violent offense, regardless of the victim is. So, you know, hopefully, this time you're going to be spending will give you time to get clean and sober and reflect upon the decisions you made. Hopefully, you'll be able to deal with some of those matters while you're in prison. So, it's a judgment and order report that in case number 21 CR 48, count 1, SUV, and are hereby sentenced to a term of 4 years incarceration at the Correction Reception Center at Orion, Ohio. And that sentences be served consecutively to the sentence going to impose in the other case. Now, case number 21 CR 101, on count 1, it's ordered that you be served with a term of incarceration at Correctional Reception Center of 12 months. And on count 3, be sentenced to a mandatory term of 3 years of incarceration. And those sentences are run consecutively to each other, counts 1 and 3, and also consecutively to the case of the sentence in 21 CR 48. Court will find that the second sentences are appropriate. First of all, it's a stipulated recommended sentence by the parties. Secondly, the offenses are committed as separate forces of conduct and are separate natures, and that one single prison term will not adequately reflect the nature or the seriousness of the offense and are not disproportionate to the conduct, since they are on the low end of the possible range of sentences in each of the 3 counts. And also, this conduct indicates that the sentence is necessary to protect the public from future crime. Now, in addition to this, again, count 3 in 21 CR 101 is mandatory, and under the law, that would be served first, and then the others would be served. Now, regarding count 1 in 21 CR 48, that is a first-degree felony, whereas count 3 in 21 CR 101 is a second-degree felony. So, under regular code provisions of the law, as you know, the court will inform you that you could be subject to be held to serve an additional period on the felonious assault charge in 21 CR 48 of 1/2 of the prison term, which is 4 years. And so 1/2 of that would be 2. So if you serve the entire prison term on all 3 of these charges, then the adult, or again, the Department of Corrections, I should say, could add up to 2 additional years on the felonious assault charge, depending upon their decision as to whether that should happen or not. The judge and the court has nothing to do with that. Now, upon completion of your prison terms, if you serve the entire prison term, and again, I'm not promising you judicial release, I probably won't be the judge when you're eligible. But in any event, if you serve the entire prison term, upon completion of that, then in case number 21 CR 48, it is mandatory that you be placed on 5 years of post-release control supervision. In the 21 CR 101 case, it's mandatory 3 years on count 3 and optional 3 years on count 1. But those are not going to happen because, I mean, even if they do, you have 5 years mandatory anyway, so we know you're going to do 5 years. Now, what that means is this. You'll be supervised on the term set by the adult parole authority and be supervised by a parole officer. The judge and the court has no involvement in that. And if they determine that during that period of time that you have violated any of those conditions, they could return you to prison, make you serve an additional period of up to 9 months during one violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony while under post-release control, then in addition to whatever sentence the judge in the new case would impose upon you, that judge would also be authorized to sentence you for violating the terms of your post-release control supervision in these cases to an additional period of 1 year, whatever time is left on that 3 years, 5 years, I should say, 5 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the case. You'll be given credit against your prison term of 57 days. We're arrested on April the 3rd, and we're in until the 5th of April, it looks like. And then they also have here from the 5th of May until June the 7th. I don't know what happened in 30 days in between. You out on bond, or were you serving that term for another court?
I was out on house arrest for 10
House
days.
arrest, okay. So, so that's a total of 57 days from May the 1st, or from 4/3 to 4/5 plus from 5/5 to the day, total of 57 days. And those will be credited to the charge on 21 CR 48, because that's the one you were being held on before you were indicted in the other case. You're also ordered to pay the court costs, which judge grant execution orders, and if you fail to do that, the clerk will collect after various means, including levy on bank accounts, wages, or other assets or earnings that you may have. If that doesn't collect it, then upon completion of your sentence, not while you're serving time, but once you get out, you could be ordered to do community service in this county, and be given credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. You're also ordered to pay restitution to the Hunt County Drug Task Force in the amount of $1,100, and that will not be discharged. Will be served your time. It doesn't go away. It stays on the books, and it can be enforced at any time. It can't be discharged for bankruptcy, and so it'll go with you until you pay it or die. You make payment arrangements for that through the victim witness office, and you'll be required to pay a service fee they charge to handle that processing. All right. Is there anything further from council?
Second.
All right. Thank you.